From the KPFK studios in Southern California,
it's the Ralph Nader Radio Hour.
Stand up, you've been sitting way too long.
Welcome to the Ralph Nader Radio Hour. My name is Steve Scrovan. I'm here with the man of the hour, Ralph Nader. Hello, Ralph.
Hello, Steve.
Before we get to our guest today, Ralph, I want to remind everyone that your latest book, Return to Sender, Unanswered Letters to the President, 2003-2014, from Seven Stories Press, is available in fine bookstores everywhere. And we did an entire episode where we discussed the book a few weeks back. So if you missed that, go to iTunes, Stitcher, ralphnaderradiohour.com, or nader.org, and that archived episode will give you a little taste of how Ralph challenged Presidents Bush and Obama on a whole raft of issues. And I also wanted to mention in his review of the book, Chris Hedges writes, quote, that he refuses to surrender and doggedly struggles against all odds for a restoration of American democracy, and the rule of law makes Nader one of the moral and intellectual giants of our age, unquote. I just said that to embarrass you, Ralph. I know you're not one for praise like that. So pick up a copy of Return to Sender, and we have an excellent show for you today, as always. Later in the show, we're going to talk to Professor Johanna Fernandez of the campaign to Bring Mumia Home. And if we have time, we'll get to more of your Facebook questions. But first, we're going to talk about terrorism and in this post-9/11 world, how our criminal justice system has been dealing with suspected terrorists. And to do that, we have as our guest Professor Wadie E.Said. Mr. Said is professor of law at the University of South Carolina School of Law, where he teaches criminal law, criminal procedure, and human rights law. His scholarship has appeared in many law journals and reviews, including those at Ohio State, Brigham Young, Indiana, Washington, and the Columbia Human Rights Law Review. And before joining the South Carolina faculty, he represented terrorist suspects as an assistant federal public defender in Tampa, Florida, serving as counsel in United States versus Al-Arian, one of the largest terrorism prosecutions in American history. His book on the subject is called Crimes of Terror, the Legal and Political Implications of Federal Terrorism Prosecutions. We're very fortunate to have him join us today. Welcome, Professor Wadie E.Said.
Oh, thank you very much. It's really a pleasure and honor to be here.
Greetings, Professor Said. Your book is just out, Crimes of Terror, published by the prestigious Oxford University Press. And in my judgment, it's long overdue because we've had a lot of unanswered questions about how, where, in what manner people subjected to charges on the grounds that they're either engaged in terrorist activity or material support for terrorism. And before I ask you the first question, I want to quote Professor David Cole, very distinguished civil rights and civil libertarian professor at Georgetown University Law Center, on your book. And here's his quote: "The war on terror has been waged not only on the battlefield, but in domestic criminal prosecutions, where the tools are not drones or infrared goggles, but sweeping laws making it a crime to provide," and he puts this in single quotes, "material support," single quote, "to blacklisted groups, and where the prosecution can rely on informants who entrap vulnerable young men into agreeing to commit manufactured crimes." Professor Said's book documents the sacrifices to due process and fundamental fairness that criminal prosecution of terrorists has already wrought, and eloquently warns against further evisceration of those principles, end quote. He puts the word terrorists in a single quote, which raises my first question. It's often been said that one of the greatest achievements of Western civilization is due process of law, that you have to have probable cause to be detained, you have to be able to confront your accusers, you have to have open judicial processes, rights of appeal, and many other examples of a very elaborate due process that's been built up by the courts and statutes over the centuries. So, Professor Said, let's start with the first question is, what's the definition of terror, and what is the distinction between stateless terrorism and state-sponsored terrorism under the laws?
Well, with respect to the definitions, I mean, there's a long-standing kind of controversy, as I'm sure you well know, about the definition of terrorism in a kind of global context. Nobody can really agree on what terrorism means because it can be manipulated for political ends. In the federal system in the United States, there are numerous statutory provisions that deal with the definition of terrorism. And while they are perhaps a little bit distinct in a word or term here and there, essentially the definition the United States employs is an act of violence for a political purpose carried out by a non-state group. And that brings me to the second part of your question regarding the difference between stateless and state-sponsored terrorism. Because states have all sorts of sovereign rights that even the United States, in the case of pariah nations it considers pariahs, it basically much easier to kind of criminalize and declare as terrorism the acts of non-state groups that don't enjoy these kind of sovereign rights or sovereign immunity. And so to actually declare states as terrorist states, there's a whole separate statutory provision that I don't really talk about in any great detail in the book. But states can be declared a state sponsor of terrorism. And I think there's basically a handful of them nowadays. Syria, North Korea, Iran, the Sudan, nations like that. The numbers are very low, and there's a kind of a special legal loophole the government has to jump through to declare those governments state sponsors of terrorism so that their sovereign rights or their sovereign immunity can be relaxed. So it's much more difficult to go after a state than it is to go after a non-state actor. And you see that the majority of the prosecutions that I talk about and the laws that I'm referencing in the book deal with those non-state actors.
Professor Said, tell me, what's the law that authorizes the U.S. government to pick a country and call it a sponsor of terrorism, like they have Iran, for example, and not pick a country that has taken the lives of many thousands of innocent citizens for political purposes, like Israel?
Well, you see, that's inherently a political calculation that Congress engages in and the executive branch engage in when they pass laws. They decide which countries are to be designated state sponsors of terror, and then they jump through the legal hoops to achieve that goal. So I think it's essentially a political calculation.
And no one can use the federal courts to challenge what they may think is a evaded designation of one country that attacks other countries in violation of international law compared to another country that happens to be on our bad list and that is designated. Is there any judicial process outside of self-definition by Congress and the executive branch as to what country gets designated and what doesn't? And as you know better than anybody, there are serious consequences when a country is designated by the U.S. to be a state sponsor of terrorism.
Yes, not to my knowledge is there any judicial recourse or judicial review of those types of designations. Those are firmly, I think the courts view them firmly within the scope of the political branches of government and completely a kind of a political question that isn't open for any type of judicial review. So,
that's the so-called, the courts say it's a political question, and they say to the person who has filed the lawsuit, take it up with Congress and the executive branch. We don't have any role here. That's one of the current withdrawal arguments the federal courts give. And the other one is standing to sue. Can you explain that? No standing to sue?
Well, yes, the idea of standing involves the person who's being harmed by the action. And if you cannot show that you have the proper standing, that you haven't been actually injured directly by the law in question, you can't be a litigant and the lawsuit can't go forward. And obviously, if you're trying to assert, for example, harms carried out by a sovereign government against other people, against non-U.S. citizens, the standing hurdle is very difficult to overcome. And in the case where a United States citizen might be harmed by a country, a sovereign nation that is not on the list of state sponsors of terror, it's very difficult to overcome this sovereign immunity type arguments in those scenarios. It's not completely impossible, but it's highly unlikely to occur.
So where a person's only recourse are the courts have two arguments. You, citizen, have no standing to sue, and even if you did, this is a political question outside our court jurisdiction. Take it up with Congress and the executive branch. Okay, let's move to the principal thesis of your book. Anybody who's read the newspaper for the last 15 years knows that thousands of people have been jailed without charges especially after 9/11, and often they weren't allowed adequate or prompt lawyers to defend them. And thousands of people were incarcerated because they were suspected as knowing something about some terrorist initiative. Why don't you just lay out the thesis in your book, and you describe very specific cases that have been in the headlines so that our listeners can see the framework of your book and delve in and want to get your book called Crimes of Terror by Professor Wadie E.Said, Oxford University Press, just out.
Yes, the main thesis of the book is that the government has been using the federal judiciary and criminal prosecutions in federal court as an alternative to the Guantanamo model. And we've heard over the years that the idea of taking people and putting them in a detention facility that's kind of situated to evade any type of judicial review and declaring them enemy combatants and holding them in kind of indefinitely in a war on terror, so-called, as a practice is something the United States shouldn't be doing, given its history and given its strong traditions of judicial review and an independent federal judiciary. And the better alternative, the argument goes, is to prosecute them criminally in federal court. And the point of the book is to look seriously at the experience and the history and current practices of trying individuals in federal court for crimes, for federal crimes that implicate or are kind of judged or put under the rubric of terrorism. And what we see is all along the line, from the initiation of an investigation through the bringing of charges, through an actual adjudication in the courtroom, to post-conviction issues like sentencing, and then finally when individuals are jailed in the Federal Bureau of Prisons and put into that custody, they enjoy, even though they are officially criminal defendants like any other criminal defendant, a drug defendant, gun defendant, a racketeering defendant, they enjoy is the wrong word. They suffer from being classified as kind of exceptional. And the government makes arguments that because we're dealing with the investigation and prosecution of terrorism, the normal rules of criminal law and procedure should bend to accommodate a more searching government investigation, or a looser rule of evidence, or a more nebulous criminal law that criminalizes something called material support to a foreign terrorist organization, or should allow for a sentencing. Again, these terms are strangely euphemistic and I don't like to use them, but in the legal parlance, they call them a sentencing enhancement, meaning someone gets a much longer sentence in prison, and it allows for a sentencing enhancement. And then finally, in the prison context, once someone has been convicted, it allows the Bureau of Prisons to put them in a special unit where their communications with the outside world are severely circumscribed. So all along the line, from the initiation of a case to the end, when someone goes to prison, the government argues that these people are exceptional. They're not like normal criminals. And the whole system has shifted.
Look at the situation you describe in Guantanamo, where well over 50 prisoners, I use the word prisoners rather than detainees, they've been there for years, have been cleared by every relevant federal agency. They've been cleared by the CIA, the FBI, the NSA, Department of Justice, some years ago, and they're still there, frying under the hot equatorial sun in Guantanamo, which is a base that was seized by the U.S. during the Spanish-American War, and it's a part of Cuba, but that's where the prisoners are sent. How can anybody explain to the relatives, much less to these 57 or 60 prisoners, they've been cleared 2, 3, 4, 5 years ago, and they're still there? What's the reason?
I think for the majority of those individuals who have been cleared, the problem relates to the fact that they come from the wrong country. Most of them, I think, are from Yemen, and Yemen has been, as you well know, a kind of a frontline state in the United States drone campaign against the movement known as Al-Qaeda in the Arabian Peninsula. And also, Yemen has been suffering over the last several years from a lot of internal instability, be it Arab Spring-related popular uprising, etc. And also there is the Houthi movement there that has been kind of in the last year or so has managed to actually kind of sort of overthrow the actual Yemeni government, which was already shaky to begin with. Plus, there's a restive population in the south of Yemen that was sort of forcibly joined with the north of Yemen to create the current country. So the country's political situation is highly unstable, and then you add the recent last month essentially bombing campaign by the Saudi military against cities and populations in Yemen, quite violent and kind of tragic in many ways. That's, I think, prevented. That's a sort of the official reason why they can't be sent back to Yemen, because the country is too unstable. And there's a fear that they would, I guess the official line is, return to fight against the United States, or there is that potential. Now, given that they've been cleared, you would wonder how that logic really works. It really is a tragic situation for those individuals who have been cleared, especially the ones from Yemen.
Yes, of course, the U.S. government has admitted by clearing them that they were wrongfully seized and wrongfully imprisoned for years, and the treatment hasn't exactly been benign day after day in those prisons. So why doesn't the U.S. say we have an obligation, A, to compensate these innocent people, and second, to bring them to the U.S. and have them live here since they're totally innocent? Why isn't that done? We do admit all kinds of political refugees, hundreds of thousands from Vietnam after the collapse of the regime in South Vietnam and other places around the world. Why don't we do that?
Again, the answer to that lies in kind of political considerations, in that this is also true if you look at the history of kind of political asylum patterns in the United States, where the individuals who tend to receive asylum tend to be fleeing from regimes with which the United States has a poor relation or is at war or something like that. They tend to come from states that the United States has a hostility to, as opposed to allied nations. They're admitting them as refugees is much tougher. There's also been a kind of a congressional ban on admitting individuals held at Guantanamo into the actual territory of the United States. And Congress, has kind of deeply challenged President Obama on this issue, because this, one of his election promises in early 2009 was he was going to close the base at Guantanamo Bay, and that hasn't happened. And part of it is there are these kind of legal strictures against, they're not absolute, but they're very difficult to kind of overcome, legal strictures against bringing those individuals here. Obviously, from a moral perspective, I agree with you, but politically, it's very difficult. There's also kind of a legal barrier in that the asylum laws of the United States basically deny status to anyone implicated with terrorism. And the bar for that in the immigration asylum context is much lower than the sort of beyond a reasonable doubt standard that you see in a criminal prosecution. So the government has to show a lot less to demonstrate that someone should not be admitted or given refugee status in the United States based on terrorist affiliations, which can be defined much more loosely.
We're talking with Professor Wadie E.Said. He's the author of the brand new book, Crimes of Terror, that has just been published by Oxford University Press. Professor Said, let's go into 4 areas that have been really troublesome for anybody who is a member of the legal profession and believes in due process of law. One is the technique that the Justice Department has used to criminalize free speech. Another is the kind of condition for dropping the prosecution and putting people in jail. If they have a weak case, they say to the defendants, who often have weak lawyers, if you plea for 7 years or 8 years in jail, we won't go for a life sentence. And the third example is the Holy Land Foundation in Texas, which was caught up into the frenzy of persecution after 9/11. And then give an example of an entrapment where they take someone who is blowing off steam, some 27, 28-year-old, and they pick up his comments, and then they get an informant to lead that person along, encouraging him to commit an act of violence, show him what the target could be, provide him even with some equipment, and then catch him and put him away for years. In the time we have left, can you go over those 4 patterns?
Okay, so with the first one was the freedom of speech. I'm just trying to jot these down.
Yeah, one like Professor El Arian, who was a professor at a Florida university in computer science. And for years, he was prosecuted, harassed, denied due process. I think now he's finally been able to go back to Egypt. Or Turkey.
Yes, yeah, exactly. Well, the interesting thing about all those examples is, you see in each prosecution a whole array of legal tools that kind of get right up to the line of legality and proper techniques. And the excuse in each instance is, the government is fighting terrorism. Now, the Larian prosecution, which I was a part of, where I represented one of the defendants, Hatem Fariz, in that case, the sort of unstated goal was, as you mentioned, to go after Dr. Larian himself, because he had been quite active and quite effective in his activism on behalf of not just Palestinian issues, but also in actually almost getting past a ban on the use of secret evidence by the government. And he had a lot of congressional support that basically evaporated in the wake of 9/11. And then he found himself in the crosshairs of the government. In that case, the government tried very hard to make political activity and sort of speech-related activity, tried to criminalize it in the sense of he would go and give a speech where he would say things that were generally supportive of a group that later ended up being designated as a foreign terrorist organization, the Palestinian Islamic Jihad. And one of the main contentions in the case was that a lot of the activity took place before the government started designating these groups as terrorist groups. And so that was a lot of the argument, was that a lot of the activity took place before there was a ban. And then after the ban, the activity that the government was highlighting implicated basically free speech activities and activism on behalf of, like I mentioned, repealing secret evidence. There wasn't much there, as the jury ultimately found, in acquitting two of the defendants outright and the other two mostly. There wasn't much that the government had in the case, but it was pushing its point that sort of nonviolent solidarity, nonviolent speech activities, if they are on behalf of groups that are disfavored by the government is going to push as hard as they can to have those groups declared as terrorist groups, and then actually construe any activities in support of them. Not sending them money or buying them weapons, but speaking out in a general sense on behalf of a cause. They're going to try their very hardest to see that as materially supporting a terrorist organization and criminally prosecute someone. So the outcome was luckily okay in that case. It was a positive outcome for the most part. But unfortunately, the government continued to go after him after his case was finished and sort of pushed him to testify against other people, and he refused to do so. And that was what they call a perjury trap, where they subpoenaed him to be a witness in another investigation, which was kind of I don't want to use the word bogus, but it was certainly a questionable investigation of an Islamic think tank in the suburban Virginia area, where the government has been investigating them for 20 plus years. They've never indicted anyone. Nothing has ever really occurred. They just wanted to kind of push him into a situation where, even though he had survived his criminal trial ordeal, where he was looking at life sentences and being convicted of a RICO crime, which was, was akin to, it's the statute used to go after, the mafia and organized crime groups. He had survived all that, and he pled guilty to a lesser crime in the hopes that he would be deported. And the government continued to hold him under this theory that he should testify. And when he refused to testify, because he said, I agreed with the government, I wasn't going to have to testify, they put him up on contempt charges and obstruction of justice charges, because the idea was, if he testifies, he'll implicate himself, or he'll lie, in which case he can be tried for perjury, or the third option, which is the one he chose, he doesn't cooperate, and then we can go after him for more charges of criminal contempt and obstruction of justice. And he finally got out of that when the judge in that case understood that the government was playing a little bit of dirty pool. Finally, first let him out on house arrest, and then finally allowed him to be deported, as he had agreed with the government many years earlier.
Before we go on to the other cases, just quickly, you think the federal attorneys in that case, given their statements and their practice and their pursuit, Professor Larian, conducted themselves warranting a charge of malicious prosecution? Because there's got to be some limit on prosecutorial behavior here.
Yeah, that's a very, again, we kind of have to think about it from a common sense, ethical perspective, where I think that, especially the statements of the attorney in that second case, that secondary case where he was in fact, subpoenaed and refused to testify. The attorney made some very questionable and inflammatory statements indicating that bias and sort of selective prosecution may have been at play. The problem is, of course, the law here doesn't really help us. There are very few cases involving prosecutorial discretion, but the ones that exist basically talk about absolute prosecutorial discretion. So in situations like that, there is no recourse, there is no sanction for a prosecutor who has maybe taken things too far. At least the courts haven't provided any basis for a prosecution like that. Although I think in this case, there was certainly a real question raised as to the motives of the actual prosecutor in that case, who said some very inflammatory things about not only the defendant himself, not only Sami Laryan himself, but also about Islam and much bigger, more troubling statements.
Professor Said, before we go to the Holy Land Foundation, run the listeners through this Tonawanda, New York case involving a few young men who went back to Afghanistan and were nailed, and I think they're now in jail for 7-8 years. Describe very briefly what the charge was by the Justice Department and the imposition of the settlement.
Well, in that case, it was, I think, one of the first sort of major high-profile prosecutions in the post-September 11th era. And I think there's a large population of individuals of Yemeni descent in the area of, I think it's Lackawanna, New York, which is near Buffalo, sort of western New York, kind of one of these old industrial towns where the industry has kind of gone away. And there was one individual who had kind of come into, a Yemeni American who had come into that town and gotten a bunch of these younger, young men from the Yemeni community in Lackawanna to go to Afghanistan. And I think all of them were basically, they went there and were kind of shocked by what they saw and shocked by this sort of training camp that this guy had led them to. And then they all sort of begged off and came back to the United States. Generally speaking, they were kind of, horrified by what they saw, kind of turned off by what they experienced, and they came back. And then
before or after 9/11?
So they had gone, yes, they had gone before 9/11, but they were prosecuted after. And the idea was, you and your listeners may remember the concept of the sleeper cell, which was sort of taking over in a kind of a hysterical fashion our thinking, that there are these groups of terrorists that are lying low, living amongst us, unbeknownst to us, who are then going to kind of jump out of the shadows and conduct an attack. And we haven't really seen sleeper cells like that in the post-9/11 era. But that thinking was prevalent. So there was a real fear that the government had that this was the sleeper cell, and they had uncovered it. So they charged them with various crimes, material support, among others, material support to terrorist organization, among others, and they're going over to Afghanistan to attend these training camps. And I think what you saw were some tactics that now have more or less gone out of favor as Guantanamo has gotten less out of favor. But one of the tactics the government was alleged to have used was to basically say, look, if you don't plead to these charges and accept a plea, we're going to send you to Guantanamo. Obviously, the government can't do that now, legally speaking. But at the time, that area of law wasn't settled, and these were threats that the men and their attorneys took seriously. So they ended up pleading, most of them, I think, ended up pleading guilty. And in other instances, at least one of the defendants was, as part of his plea deal, was brought in to testify against other defendants in various criminal terrorism prosecutions that the government brought, in a kind of the link between the testimony of that, Yemeni American fellow and these other cases was not entirely clear as to how it was relevant, but the government continued to use it because I think the government has a view of kind of terrorism in the war model as the enemy. So, distinctions between groups and political motives and their ethnic background, their linguistic and cultural background are not important. Once a group has been, basically painted with that terrorism brush, the government has a certain view of terrorism as monolithic. If that guy's a terrorist over there, well, this terrorist over here, there's a lot of kind of compatibility, and they're all terrorists. So, what this terrorist says about that terrorist is relevant.
So how many years did they have to go to jail for?
I'm not sure. I think the plea bargains in those cases were in the realm of 8 to 10 years, something like that, 7 to 10 years in those cases.
Yeah, I think that's correct. Let's go to the Holy Land Foundation. Prosecution, exoneration, reprosecution, secret witnesses. This has been very, very inadequately covered by the press, even the press that covers the whole Justice Department's involvement in these cases.
Yeah, the Holy Land Foundation prosecution is a particularly poignant and important one, I think, in a general sense, but also in the book. I cover it over several different areas of the book because it impacts in many areas of the law. Basically, this was the largest Muslim charity in the United States, operating pre-September 11th. And the government had long suspected it of being tied with the Palestinian group that's designated as a foreign terrorist organization, Hamas, the Islamic resistance movement in Palestine. And basically, the government kind of, I think, essentially admitted that what the group did was send money to Islamic charities in the Palestinian territories, that those charities were, in fact, legitimate. Initially, the thinking was, according to the government, that these charities were part of the Hamas operation, so money for legitimate charity, orphans and widows and food and education, etc., would free up money for weapons on the theory that money is fungible. That's the classic basis for a material support charge. Money is fungible, and money for charity frees up money for terrorism. Now, the problem in that case was several-fold. First, the Holy Land Foundation made repeated attempts to interface with the government to find out what it is they can do to continue their operations without offending or without falling foul of the anti-terrorism laws, the material support law in particular. The government wasn't really interested in kind of helping them out. They had kind of ID'd them as a major funder of terrorism, and they weren't interested in cooperating. So the facts here are important in that the group itself tried very hard to comply with the government. The government wasn't interested. The government was interested in going after this group. Then when they indicted the officers of the group, the theory, while the case progressed, shifted. So instead of money is fungible and what the Holy Land Foundation and its officers were doing was sending money to Hamas via charities that freed up money for weapons and violence, the government shifted its point to argue that what in fact this group was doing was giving money to legitimate charities, we don't dispute that are affiliated with Hamas, and not that money is fungible, money for humanitarian purposes frees up money for violence, but that these charities, being affiliated with Hamas, doing legitimate work, enhance Hamas's reputation within the community, that is to say the West Bank and Gaza, and as a result, that constitutes material support. That is to say, not material support in the form of money, material support in the form of legitimacy.
Could you just indicate the two stages of the litigation, what the juries found the first time, and then how the government came back a second time?
Well, basically, the juries at the end of the first prosecution, the jury essentially was ready to acquit most of the defendants on most of the charges. And then there was a weird scene at the end where the judge asked them if that was in fact their verdict, and one or more of the jurors disagreed. So the judge declared a mistrial. And so that allowed a second prosecution where the government was allowed to make arguments that it hadn't been highlighting the role of Hamas in the Islamic charities in the West Bank and Gaza, the alleged role of Hamas. And they did it by way primarily using the secret or the testimony of an expert witness whose identity remained secret. This was an Israeli intelligence officer. They actually had two. They were basically allowed to testify that these committees were viewed by the Israeli government as part of Hamas. The problem was the defendant's lawyers couldn't challenge this expert witness's credentials because it knew nothing about him. Didn't know his name, didn't know his background, didn't know the basis on which he was making these conclusions. And it also sent the jury a message that these defendants are so dangerous that we need secret anonymous witnesses whose identity has to remain secret because the defendants are threatening them. And that in the end led to conviction on all the charges and long prison sentences.
And where is the case now?
Well, unfortunately, the appeals of the defendants failed and at the Fifth Circuit Court of Appeals, the Federal Court of Appeals. And the Supreme Court denied certiorari in that case, so it declined to review the case. So they're in a kind of a, hopefully making a habeas motion, trying to struggle via other means. But the legal avenues, unfortunately, look pretty narrow, if not actually closed to them.
Well, this involves people in their 60s. They're immigrants living in Texas from the Muslim world, and the families are in a state of disbelief that they could be convicted based on secret foreign witnesses brought into the courtroom in Texas without any chance for cross-examination. It fits the definition of a kangaroo court process, and the Supreme Court should never have denied cert in that situation. This is a true scar on the American system of justice. Anyway, we're running out of time, Professor Said. I hope we've given our listeners an appetite to read more in your book, because there's no such thing as getting away in a country that calls itself subject to the rule of law by these kinds of prosecutions of people with funny-sounding names, and it doesn't affect the Smiths and the Jones and the McCardles. That is, doesn't affect the rest of the American people. The listeners should also realize that this book describes a process that was once described by Professor David Cole in an article he wrote, basically saying that most of these cases were manufactured and that it's hard to find more than a handful of real terrorists that were prosecuted and convicted in the United States out of the thousands of people who are subjected to malicious treatment, illegal detention, entrapment, and so forth. One last quick point. What's your best figure on how many real terrorists have been convicted in this multi-billion-dollar law enforcement process, also involving local police, since 9/11?
Well, I think if the numbers are something like 500 to 600 terrorism defendants prosecuted in the post-9/11 era, one statistical study, these are kind of informal statistical studies that scholars and investigative journalists have done, one study put it at about 1% of that number being actual operational terrorists, that is to say, terrorists constituting a violent threat. Another study put it at about 3%. In total, we're not talking about a number really greater than 20, 25 people in the nearly 14 years after September 11th, 2001. I don't know that that number really truly justifies the kind of mass commitment of resources and personnel and investigative attention to the problem of terrorism in the United States the way it's been. So I think the numbers are pretty minuscule compared with the threat as it's been portrayed to us, the people, as we, on a sort of a daily basis, as we see now anyway. Every week, or it seems that there's a new indictment of someone who wanted to basically go join ISIS. And a lot of those cases are manufactured as well by a government informant. And that only comes out later after an individual has basically pled guilty, because there's no way of proving otherwise.
Not to mention the horrific consequences following 9/11 with the invasions of Iraq and Afghanistan and the U.S. soldiers and trillions of dollars being spent, resulting in even more proliferation of violent groups spreading into 20 countries against the United States. Could you tell the listeners, Professor Said, how they can contact you before we thank you and conclude this segment of our program?
Sure, of course. I can be reached by email is the best way. It's said@law.sc.edu. That's my address at the University of South Carolina in the law school.
Want to repeat it and spell it out, please?
Oh, sure. It's Said, SAID, @law.sc.edu.
Thank you very much. We've been listening to Professor Wadie E.Said, the author of the brand new groundbreaking book, Crimes of Terror, published by the prestigious Oxford University Press. Thank you again, Professor Said.
Oh, thank you so much. Thank you.
Thank you, Professor Said. You're listening to the Ralph Nader Radio Hour. We'll be back after this.
Stand up. Oh, stand up.
From Pacifica, you're listening to the Ralph Nader Radio Hour, www.nader.org.
Stand up. Oh, stand up.
Welcome back to the Ralph Nader Radio Hour. I'm Steve Scrovan along with Ralph, and our next guest is Professor Johanna Fernandez, who teaches 20th century U.S. history, the history of social movements, the political economy of American cities, and African American history at Baruch College of the City University of New York. She is currently working on the campaign to bring Mumia home. Please welcome Dr. Johanna Fernandez.
Thank you so very much for having me on your show.
Professor Fernandez, in a statement that you and Mumia Abu Jamal's lawyer, Heidi Bogosian, released on April 23, 2015, you raised the question, and I quote, "What does it mean for hundreds of thousands of prisoners in the United States when the world's most famous prisoner faces possible death from medical neglect in a Pennsylvania prison, often called the voice of the voiceless for his countless publications and broadcasts revealing the injustices of the criminal justice system? Mumia Abu Jamal has seen his health slip away in a matter of months. Thousands of supporters worldwide and frequent visitors could not stop the burning black lesions that covered his entire body or the profound fatigue that since January has sucked him into trance-like sleeps, or guards who punished him with denial of calls, visitors, and yard for sleeping through morning alarms and the morning count. What does it say that on March 30th, Mumia Abu Jamal fell unconscious with uncontrolled and undiagnosed diabetes?" End quote. Before we get to the present emergency and the condition, which is attracting worldwide attention, could you tell our listeners who aren't that familiar with the Mumia case what he was charged of, when, what he was convicted of, and why did Amnesty International put out a major report on the lack of due process and the kind of evidence that was used in his trial?
Mumia Abu Jamal is wrongly convicted of killing police officer Daniel Faulkner on December 9th, 1981. His case is riddled with police corruption, tampering with evidence to obtain a conviction, prosecutorial misconduct, judicial bias of the worst kind. A court stenographer who was working in the court at the time that his trial was going on overheard the presiding judge in the case, Albert Sabo, say, quote, "I'm going to help them fry the nigger," referring to how he was going to instruct the jury. There was a fourth person at the scene of the crime by the name of Kenneth Freeman, who is believed to have been the person that killed Officer Faulkner. That person's presence at the crime scene was suppressed at trial by the prosecutor, Joe McGill. And crimes investigation journalist by the name of Patrick O'Connor, in his book, The Framing of Mumia Abu Jamal, which was reviewed positively in the New York Times, argues that it was Kenneth Freeman who killed Officer Faulkner. 15 of the 35 police officers who collected evidence in Mumia's case went down in an investigation on police corruption in Philadelphia. They were convicted and jailed only weeks after the end of Mumia's trial. But the jurors who heard evidence and arguments and testimonies from the police could never have known that the police who were testifying in this case were lying and would be convicted weeks after the end of Mumia's trial for lying and tampering with evidence to obtain a conviction. About 7 years ago, some photographs surfaced. They were the first photographs taken of the scene of the crime by a freelance photographer. His name is Pedro Polikoff. These photographs are known as the Polikoff photographs. And these photographs show conflicting evidence. They demonstrate how the police tampered with evidence at the scene of the crime. They also show an Officer Forbes mishandling the guns that were found at the crime scene, holding the guns with his bare hands. This same police officer, Officer Forbes, testified at trial that he properly handled the guns that were retrieved at the crime scene. This is important because Mumia was convicted and put on death row in the absence of material evidence, only with the testimonies of those who were called to testify against him. And the bullet that killed Officer Faulkner could not be linked to Mumia's gun because the coroner lost a fragment of the bullet that led him to say that he could not conclusively link the bullet that killed Officer Faulkner to Mumia's gun. Now, as you probably know, Mumia was a journalist by day and a cab driver by night. He had recently acquired a gun because he was the victim of an assault, and that's why there was a gun at the crime scene. So there are all kinds of inconsistencies in this case, but the evidence of Mumia's innocence has been prevented from being fairly addressed in the courts for all kinds of different reasons, including the fact that the Fraternal Order of Police, which is a very powerful organization, the largest police organization in the world, has influenced the appellate process. And in fact, in Mumia's most important appellate trial, the judge presiding over the trial, Ronald Castile of the Pennsylvania Supreme Court, was asked to recuse himself by Mumia's attorneys because of his relationship with the Fraternal Order of Police. He had been named Man of the Year by the Fraternal Order of Police that same year that Mumia's appeals were being heard, and the Fraternal Order of Police had funded his campaign to the judgeship in the Pennsylvania Supreme Court. And he wrote a lengthy response to Mumia's attorneys saying that he would not recuse himself because if he recused himself, 5 other judges in the Pennsylvania Supreme Court would also have to recuse themselves because they too had received funding for their campaigns from the Fraternal Order of Police. For your listening audience, it's important to know that in Pennsylvania, judges run for election to the Supreme Court and to other courts.
And Professor Fernandez, listeners should know that what you just heard was part of the reason why a very detailed report by Amnesty International recommended a new trial for Mumia based on these and many other irregularities affecting his first trial. He was put on death row, and then I think in 2012, the judge, recognizing some problems, took him off death row. And now he's in serious medical peril. And could you, before we conclude, describe the present emergency situation with a prisoner who has one of the largest global audiences for his regular radio programs and other broadcasts and writings?
Mumia fell into diabetic shock in March when an allergic reaction to a steroid shot that was administered for a severe skin problem went unmonitored by doctors. He was rushed to a local medical center, its ICU, and he remained there for 3 days before he was prematurely transferred back to the prison. In the hospital, he registered a blood sugar level of 779. Just to give you a sense of perspective, a blood sugar level of 800 registers diabetic coma. He also had an abnormally high sodium level at 168, which is potentially fatal. He was transferred prematurely within 3 days back to the prison infirmary to be taken care of by doctors who had overseen his medical mistreatment. And the next day, he again fell in the bathroom and was in the bathroom for 45 minutes before a prisoner discovered him. His skin condition has continued to deteriorate. Initially, the doctors at the prison infirmary said that it was eczema. About 3 weeks ago, they told Mumia that they did not know what exactly was wrong with his skin. Just to give you a sense of what it looks like, Mumia's skin is black, jet black, and hardened everywhere in his body, his full body, neck, and face. He has open sores. It is very painful and itchy. He also shaked uncontrollably during my last visit approximately a week and a half ago. I visited him for 3 to 4 hours, and his skin seemed worse. His earlobe seemed to be detaching from his skin in his head. And this is the condition under which he's been kept in the prison and the prison infirmary and in his cell without proper specialized medical care. Recently, however, he was transferred back to a different hospital in Danville, Pennsylvania. But what we are protesting is the fact that since May 12th, since he was transferred to a different medical facility, the DOC and the hospital has prevented access by his doctors and by the DOC to counsel. So Mumia has not spoken to counsel since he was hospitalized on May 12th. And as you know, this is a violation. This is a constitutional violation. All prisoners have a right to access to the courts and to their attorneys, especially in an emergency of this kind, of hospitalization, and what appears to be a deteriorating and serious medical condition. Now, what we know is that the skin disease is a reflection of deeper systemic problems in Mumia's body. And we are asking that the DOC allow Mumia an independent team of specialized doctors from around the world who are at the ready to diagnose this problem. I also want to say that there is a health crisis today in Pennsylvania's prison amongst prisoners. There's a crisis of prisoners being infected by coal ash. So Pennsylvania produces an enormous amount of coal ash, and there are dozens of prisoners across the country who are complaining of the skin problem that's severe. And those who've done an investigation of the matter say that the problem is scleroderma, which is a disease of the skin and internal organs found in minors because of their exposure to coal ash. A lot of the prisons that have been built recently in Pennsylvania have been built close to these mountains where coal ash is dumped by companies, by garbage disposing companies. And this is essentially an environmental crisis of epic proportion that is killing prisoners and ordinary people across the state of Pennsylvania.
Professor Fernandez, in conclusion, how can people reach you to get more information and to join the effort for justice for Mumia?
Well, we're asking listeners to contact the prison where Mumia is held when he's not hospitalized, SCI Mahanoy in Mahanoy, Pennsylvania. The number of the superintendent, John Carestes, is 570-773-2158. Once again, that's 570-773-2158. We're also asking people to call the Department of Corrections. The number to the Department of Corrections is 717-728-2573. Once again, the number to the Department of Corrections is 717-728-2573. the head of the Department of Corrections is John Wetzel, and we're asking people to ask for two things: that Mumia be allowed to see and speak to his attorneys and to his closest family, including his wife, and that the Department of Corrections allow Mumia to be seen and treated by an independent team of specialists who are equipped to deal with Mumia's serious and potentially fatal medical condition.
And Professor Fernandez, lastly, what is your contact number for the listeners before we conclude?
You can find me online at Baruch College of the City University of New York. It's History Department, but people can email me at johanna.fernandez at Baruch, BARUCH, .CUNY, CUNY.edu.
Thank you very much. We've been listening to Professor Johanna Fernandez on the present crisis involving the long-term incarceration of Mumia Abu Jamal, who is now in medical peril and who needs access to his lawyers and to readily available first-class independent team of physicians. Thank you very much, Professor Fernandez.
Thank you very much for having me on your show.
I want to thank our guest today, Professor Wadie E.Said, author of Crimes of Terror, The Legal and Political Implications of Federal Terrorism Prosecutions, and Dr. Johanna Fernandez of the Campaign to Bring Mumia Home. My name is Steve Scrovan. This is the Ralph Nader Radio Hour. Talk to you again next week, Ralph.
Thank you very much, Steve. Thank our listeners. Spread the word. More radio stations, more action in response to these wonderful renditions by leading citizens.
Stand up, you've been sitting way too long. Thieves in the temple, too much money changing hands. It's really very simple, just make a list of demands. We demand freedom, we demand equality, we demand justice. It ain't gonna happen until folks like you and me just stand up.